Good morning, everybody. Can you hear me now? Yes? Okay. My name is Daniel KANSTROOM, and as faculty director of the Rappaport Center for Law and Public Policy at Boston College Law School, it is my great pleasure to welcome you to this event as part of a great series that we have planned for this year at the Rappaport Center. Today's event is rather broadly entitled, quote, "After the Mueller Report, the Attorney General, the White House, and the Congress, a Constitutional Crisis, question mark." As you can tell from that title, we envision a very wide-ranging, a very provocative, and legally sharp discussion about many different things. The Mueller Report itself, of course, its legal and political effects and legacy, separation of powers, impeachment, electoral integrity, national security, and so on. So before I introduce our outstanding array of panelists for today, let me offer a brief framing, just sort of a sketch, of how we got here and where we seem to be now. And I'll ask our panelists to correct or elaborate as needed as we go forward. In July 2016, exactly 100 days before the 2016 election, the FBI, then led by James Comey, commenced an investigation called Crossfire Hurricane into links between associates of Donald Trump and Russian officials and suspected coordination between the Trump 2016 presidential campaign and Russian interference in the 2016 elections. That investigation was still ongoing when Mr. Comey was summarily dismissed by Mr. Trump on May 9, 2017. 8 days later, another FBI investigation, this one for obstruction of justice, was opened by then acting FBI Director Andrew McCabe. Attorney General Jeff Sessions had recused himself from the investigation into the Trump campaign, so Rod Rosenstein appointed Robert Mueller as a special counsel, not as an independent counsel, a point to which I expect will return, to take over and expand these investigations. The scope of the special counsel's appointment included, quote, "any matters that arose or may arise directly from the investigation," and, quote, "any other matters within the scope of 28 CFR 600.4a, which authorizes a special counsel to investigate and prosecute any attempts to interfere with its investigation, such as perjury, obstruction of justice, destruction of evidence, and intimidation of witnesses." There were some subsequent other authorizations, but we don't need to get into that now. The special counsel investigation ended on March 22nd, 2019. It resulted in 34 indictments, including of several former members of the Trump campaign, many of which are still being tried. 8 people have pled guilty so far, I believe. The special counsel issued more than 2,800 subpoenas, executed nearly 500 search and seizure warrants, obtained more than 230 orders for communication records, obtained almost 50 orders authorizing the use of pen registers, made 13 requests to foreign governments, and interviewed approximately 500 witnesses, including almost 80 before a grand jury. The major findings of the report are as follows. 1, the Russian government, quote, "interfered in the 2016 presidential election in sweeping and systematic fashion," end quote, and, quote, "violated U.S. criminal law." 2, as to so-called collusion, the report makes clear that, quote, "in evaluating whether evidence about collective action of multiple individuals constituted a crime, we applied a framework of conspiracy law, not collusion." And this was understood to require an agreement, express, tacit or express, and the Russian government, and more than two parties simply taking actions that were informed by or responsive to the other's action. So the report concludes, quote, "while the investigation identified numerous links between individuals with ties to the Russian government and the Trump campaign, the evidence was not sufficient to support criminal charges," end quote. However, the investigation did establish that several individuals affiliated with the Trump campaign lied to the office and to the Congress about their interactions with Russian-affiliated individuals and related matters. Those lies materially impaired the investigation of Russian election interference. Further, the office learned that some individuals had deleted communications or used methods that couldn't be retained, and so the report says the office cannot rule out the possibility that that unavailable information would shed additional light on the events described in the report. Now, in Volume 2, the report deals with obstruction of justice. It notes first that it is bound by an OLC, Office of Legal Counsel opinion, finding, quote, the indictment or criminal prosecution of a sitting president would impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions in violation of the constitutional separation of powers. So the special counsel accepted OLC's conclusion. And apart from that, the special counsel said, we recognized that a federal criminal accusation against a sitting president would place burdens on the president's capacity to govern and potentially preempt constitutional processes for addressing presidential misconduct. The OLC opinion noted the special counsel does recognize that a president does not have immunity after he leaves office. The report says we considered whether to evaluate the conduct we investigated under Justice Manual standards governing prosecution, but we determined not to apply an approach that could potentially result in a judgment that the president committed crimes, end quote. And this was due to what were called fairness concerns, and we'll talk about that a lot. And finally, there was this. Now, bear with me, because by my account, what you're about to hear is a quintuple negative with a subjunctive framing, which works very well in German, but not as well in English. Quote, if we had confidence, after a thorough investigation of the facts, that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, however, we are unable to reach that judgment. The evidence we obtained about the president's actions and intent presents difficult issues that prevent us from conclusively determining that no criminal conduct occurred. Accordingly, while the report does not conclude that the president committed a crime, it also does not exonerate him. So, with all that in mind, let's turn to our excellent panelists. They all have long, impressive resumes, but in the interest of time and with apologies to them, I'm going to offer only very short bios of each of them before we begin with the first round of questions. To my immediate left is Joyce White Vance, who is the Distinguished Professor of the Practice of Law at the University of Alabama School of Law. She served as the U.S. Attorney for the Northern District of Alabama from 2009 to 2017. She has served on the Attorney General's Advisory Committee and was the co-chair of its Criminal Practice Subcommittee. Before becoming U.S. Attorney, Professor Vance served as an Assistant United States Attorney in Birmingham for 18 years. Next, Chuck Rosenberg is a senior counsel in Crowell and Mourning's Washington, D.C. office. He served from 2015 to 2017 as the acting administrator of the Drug Enforcement Administration. Prior to running DEA, he served as the chief of staff and senior counsel to FBI Director James Comey. He also served as the U.S. Attorney for the Eastern District of Virginia from 2006 to 2008, and prior to that, he served as the U.S. Attorney for the Southern District of Texas. Before that, he served as counsel to then FBI Director Robert Mueller, counselor to Attorney General John Ashcroft, and chief of staff to Deputy Attorney General Jim Comey. Finally, he served as the Assistant U.S. Attorney in the Eastern District of Virginia for 6 years before that. Frank FIGLIUZZI, to whom I should say we are especially grateful for his service as a Rappaport Center Advisory Board member, is the former FBI Assistant Director for Counterintelligence, who served 25 years as a special agent. Frank has held senior FBI leadership positions in major American cities and was appointed the FBI's chief inspector by then Director Robert Mueller to oversee sensitive internal inquiries, shooting reviews, and worldwide audits. Following his FBI career, Frank became a corporate security executive for a Fortune 10 company and led global investigations, insider threat, workplace violence prevention, and special event security for 300,000 employees in 180 countries. As the Bureau's head of counterintelligence, Frank directed all espionage investigations across the U.S. government. He frequently briefed the White House, Congress, the Director of National Intelligence, and the Attorney General. Michael Sullivan is currently a partner at the Ashcroft Law Firm. He was the Plymouth County District Attorney from 1995 to 2001. He was then appointed U.S. Attorney for the District of Massachusetts. He was the prosecutor in the 2001-2002 criminal trial of Richard Reed, widely known as the Shoe Bomber. He also prosecuted airport workers at Logan Airport who were accused of lying about their nationality on job applications. Mr. Sullivan formed a task force dedicated to catching James Whitey Bulger and oversaw the prosecution of former FBI agent John Connolly. In 2006, President George W. Bush appointed and then nominated Mr. Sullivan to be director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. So let's give a welcome to all of our panelists, and we'll begin. Thank them all for coming. The plan here is to start with a first round of questions. Each panelist will get a couple of questions, have about 5 minutes each to answer them. Then we'll have a second round. Then we'll have a lightning round at which each panelist can come up with something that they disagree with or that they think was beautifully phrased as it may go. And then we will open the floor to questions for as long as we possibly can. So Joyce, let's begin with you, if we might. Could you help us as a start to understand a couple of basic things? The first one is, what did Mr. Mueller's team actually and implicitly conclude about the two main questions of collusion and obstruction? I mean, did the report find there was collusion or not? And what is collusion anyway?
So Dan did such a great layout of this that I'll just agree with what you said and elaborate a little bit more. Oh, am I? Thanks. I've had problems with microphones the last couple weeks. Is that on now?
Yeah.
Okay, great. So elaborating on where Dan started, I think the most important point to take away from the entire Mueller report is the point that's the most often overlooked. And that's that Mueller found that there was sweeping efforts by Russia to interfere with the 2016 election. That, I think, when we hear about Mueller being troubled about the rollout of the report, when you get that bit of body language from him in his press conference, my suspicion is that it's because that point has almost been overlooked. And yet we have a foreign threat to something that's so central to our democracy. And there has been, instead of the all-of-government effort that one would expect to protect future elections, almost a gloss over. So that, I think, it's very important to keep in mind. Collusion, conspiracy, there's been so much made out of this. I think we all know the history now. The Attorney General, Bill Barr, was able to deliver to the American people a summary, or his summary, of the Mueller report before the report itself was actually released. And so that has resulted in a public understanding that the report found no collusion and no obstruction. And that's not exactly what the report says. As Dan told you, Mueller was very clear about the fact that he was not considering collusion. And that's because collusion is not a crime. It's not a legal term that's laid out in 18 U.S. Code, the portion of the criminal law that federal prosecutors most frequently deal with. Instead, Mueller looked at a very narrow crime, at conspiracy, at a corrupt agreement and an overt act in an effort to violate the law. And so Mueller looked very carefully at the evidence he compiled to determine whether or not there was a conspiracy. He found that the evidence did not establish a conspiracy, although he was careful to say that there were some problems that he faced in the investigation. People who lied, people who exercised privilege and didn't testify, evidence that was contained on apps that they weren't able to look at, evidence that was found offshore, witnesses who answered written questions as opposed to appearing for interviews. And so he faced some issues, and he said, although the evidence doesn't establish conspiracy, had we not encountered these problems, or were we able to obtain some of this additional evidence, we might view things in a different light. We don't know. So that's a no. That's a no prosecution on conspiracy from his point of view. But obstruction is a very different sort of an animal. The Mueller report lays out 10 potential items of obstruction. Over 1,000 federal prosecutors have now signed on to a letter in which they say that evaluating the evidence, if this were not the President of the United States, who DOJ policy prevents the indictment of, if this were just you or me, that we would be under indictment for obstruction based on one or more of these acts, which include items like the president's efforts to have White House counsel Don McGahn fire Mueller, the president's effort to have McGahn lie about that situation once it came to light. So there are a number of incidents there that many people believe would support an obstruction charge. And of course, Mueller has this sort of tortured analysis, or at least it's tortured If you're not a former appellate lawyer, and I spent many years as an appellate lawyer in my office, and so to me what this says is that Mueller was worried in the language that federal prosecutors use, not just with the notion of obtaining a conviction, but also sustaining a conviction, making sure it stands up on appeal. And this means he was deeply respectful of the policy against indicting a president, while understanding that in the future, prosecutors or maybe Congress would be looking at this evidence and making sure he did not do anything that might taint some sort of a criminal process down the road. I think I'll stop there for now.
Let me ask you one brief follow-up. What do you make of the argument that some have made that the president's inherent broad executive power means that obstruction, at least on these facts, is not and cannot constitutionally be a crime for him?
Right. So this is this executive power argument, the subject of the 19-page memo that Mr. Barr wrote and sent to the White House while he was, let's just say, campaigning to be Attorney General. We're among friends, right? Chuck is going to get on me, but we'll just call it what it is for once.
Well, there is a lightning round,
so you can get back.
No.
So there's this very expansive view that circulates. Barr is certainly on the outer fringes of that, and this view that an executive can't commit obstruction only goes just so far, even with him. So, for instance, a president who committed a clearly illegal act that wasn't part of his executive layout would still be chargeable. And we actually have that in the Mueller report, where we have this just extraordinary situation where the news breaks the story about 6 months after it happens, that the president tried to get McGahn to fire Mueller and that McGahn refused. And the president has a series of meetings, 4 meetings. 3 of them, he asks people to meet with McGahn. The 4th one, he actually holds himself with McGahn in the Oval Office, and he says, you have to go out and refute this. I need a document to go into the record that'll refute this. And McGahn refuses to do it. And that's outside of executive power by anyone's assessment. So I think ultimately, this argument is a nice legal try. It's confusing and hard for folks who haven't been to law school to follow, and that may be part of its virtue, but it doesn't make a difference here.
I should point out that the first article against Richard Nixon was obstruction of justice, for those who may remember. Thank you, Joyce. Chuck, could you elaborate a bit on the difference between an independent counsel and a special counsel and why it matters?
Yeah, sure. So Ken Starr was an independent counsel under a statute that expired in 1999. And so he reported to a group of federal judges who appointed him and who gave him authority to conduct his investigation. He was not bound by Department of Justice policy. And so that's why, for instance, you see a Starr report which recommends charging or lays out a method to charge the President of the United States. When that statute expired, many people thought, whatever your view on this, many people thought that Starr's report was salacious, or he had gone too far, or the investigation had strayed from its sort of design course. Congress let the statute expire, and they needed another structure to replace it. And the structure they came up with in 1999 to replace it was this thing called a special counsel. That's what Bob Mueller is, a special counsel. Mueller's authorities are very different than Starr's in some ways and very alike in others. The way in which they're alike is pretty simple. They both had use of the grand jury and the FBI to conduct an investigation. They used the tried and true method of prosecutors and FBI agents, and all of us were prosecutors and FBI agents up here in order to find the truth. But in the end, Mueller was cabined. He was cabined in a way, Dan, that you referred to and that Joyce referred to, in that he is bound by Department of Justice policy. He is a subordinate officer within the Department of Justice. He reports to the Deputy Attorney General and ultimately to the Attorney General. And so if existing Department of Justice policy says you can't charge a sitting president, that would bind Bob Mueller as special counsel, but would not have bound Ken Starr as independent counsel. And that's probably the most important difference. And I'm done. And you didn't even have to hold up the sign telling me to shut up.
Well, maybe if I might just follow up on that, because I think we'll come to this. Has this question, this is obviously a very profound question of constitutional law, has it ever been reviewed by the legal system, by a court, by the Supreme Court, or is this, and I use the word merely advisedly, but is it merely OLC Policy, what do you think of the strength of it?
It's policy. And by the way, this policy came first from the Nixon administration in 1973, I think. That's when the first opinion was written, and was reiterated by the Clinton administration in 2000. So we have it issued by the Department of Justice twice, once under a Democratic president, once under a Republican president. In the main, I think it's probably right. Although, to answer your question, Dan, it has never been adjudicated. It has never been litigated because it binds the Department of Justice. Probably the opportunity to have litigated it would have been if Ken Starr had charged a sitting president. It wouldn't have been the policy we were litigating. It would have been the constitutional structure, whether or not a sitting president can be charged while in office. As I said earlier, I understand it. It makes sense to me. I'm not sure we want to live in a world, and I'm not a fan of this president. Please don't misunderstand me. I'm not defending him. But I'm not sure we want to live in a world in which a president can be charged with a crime while in office. The Constitution provides a path out of for a bad president. It's called impeachment. And I think that probably and logically is the sole remedy, putting aside the election of 2020.
Thank you. And just to reiterate, I think it is clear that a president, after leaving office, can be criminally charged, but then you run into statute of limitations questions, whether that might be told or not.
Right. I mean, the conduct Joyce described took place in 2017. The statute of limitations for most federal crimes is 5 years. If the president lost re-election in 2020 and left office in 2021, you'd still have about a year and a half or so left on the statute of limitations for most of the obstructive conduct.
Great, thank you. Michael, you're a Boston College law undergraduate, so I'm going to skip over you and ask you to just wait a moment. We'll go to Frank and then back to you. Frank, let's move from the criminal law questions to a somewhat broader array of concerns. The special counsel inquiry, if I'm correct, began as a counterintelligence investigation. Can you talk about what is that? What happened to that counterintelligence case, and what the report tells us about Russian interference in the 2016 election, and how significant an issue you think that is?
Yeah, certainly. I think if someone had told me several years ago that I would be speaking publicly about a specialty within the FBI that I worked in relative obscurity because it was largely classified, I would have told them they were crazy. But there seems to be great interest in what is counterintelligence. And essentially, you need to know this. The mission of any counterintelligence officer is to detect, deter, and defeat threats to our national security. So put simply, FBI agents get up every day and fight a battle against foreign intelligence services who wish to do us harm. And almost every foreign power has an intelligence service that in some way deploys people and officers within the United States in various forms, some under diplomatic cover, some much harder to detect, all with a goal of in some way taking something from us or undermining the country. And it played out in spades with regard to the Mueller report and volume 1, where we learned clearly that in this case, the Russians made a systematic effort to not only interfere with our election, but which, by the way, I remind folks is goal number 1. I often hear people say, well, the Russians were all about helping Trump. And I correct those folks and say, actually, that was a secondary goal. The first goal of the Russian intelligence service is to actually sow complete discord and chaos within the United States and to undermine us. And I give them an A+ for that effort so far. We may not be able to prove that they actually caused a win and took candidate Trump to President Trump. We may not be able to prove that, but what we can show is that they successfully interfered with our electoral process. And we show that through over 24 indictments by Bob Mueller of Russian operatives. 12 Russian military intelligence officers indicted for what? For hacking into the DNC, the Democratic Party, stealing information, and then disseminating that information in perfectly timed packets through the WikiLeaks organization. The second cache of or cadre of Russians indicted were operatives and cutouts in Russia who ran a social media propaganda campaign that caused many of us in this room to open our Facebook pages, our Twitter feeds, our news streams, and find propaganda that was not only not true, but actually may have done harm to certain candidates and caused us to think a different way. So those origins of the special counsel investigation started in the Hoover building at 10th and Pennsylvania Avenue and caused the opening of a counterintelligence case to determine to what degree our adversary was meddling with the counterintelligence case. Now, where did it go? That was a part of your question. And that is a crucial question because, as Joyce alluded to, the Mueller inquiry was limited and constrained to criminal questions. Was there a criminal conspiracy between the campaign and Russia? Was there criminal obstruction by the President of the United States? And I'm here to tell you that the goal of a counterintelligence case is not by any stretch putting people in handcuffs. That is actually very rare. What it is to detect, deter, and defeat the efforts of foreign adversaries. So the question of where that CI case went is one that causes me great concern because the Senate and House Intelligence Committees, who typically oversee significant counterintelligence investigations, what are they telling us? They're telling us they have yet to be substantively briefed on this counterintelligence case. What did Andy McCabe, the former acting director of the FBI, say publicly? That he added Donald Trump's name to the caption of that counterintelligence case. Is it still there? Have we resolved the seminal counterintelligence issues, which are, has our president been compromised by a foreign power? Is he vulnerable to continuing compromise? Was he recruited in some way? And what truly motivated his behavior to align himself with Vladimir Putin to this day and Russia? Those questions remain unanswered.
Thank you. I'm sure we'll return to this question, but I think I'm not the only one who would value or appreciate just a brief recitation of what do you think we ought to be doing now that we're not doing. Sorry, you can't hear that? Oh, I was asking could you hear Frank's presentation? Yeah, so it's just me. Yeah, but okay. That's okay. So the question was just a brief set of ideas of what we might do now going forward in regard to that problem.
The thing that I think we should all be focused on is the upcoming election, because not only has Bob Mueller told us that this is a grave concern for us, foreign meddling with our election process, but the current FBI director, Chris Wray, has testified that this is an ongoing concern that's not going away, and other heads of intelligence services have told us the same thing. So the question we must all ask, and the answers we must demand from our elected representatives, is what are you doing about it? What are you doing to secure the election in my city, my county, my state? And we should ask that at varying levels of government, right down to the city hall where you live and your local registrar of voters. Because my great concern is not just that the results of an election could be hacked and altered, but rather that much smaller interferences at the local registrar of voters level, where you show up to vote on election night and they tell you your name's not on the roster. Those kinds of local hacks are far more likely to happen than with standalone voting machines. And we need to demand some answers from the people responsible for our election.
Thank you. Michael, let's return to the criminal law aspects of this. One of the themes of the report that you see in a couple of different places is that the evidence, the investigation, did not establish something. The evidence did not establish conspiracy, for example. What does that actually mean in this context, that it did not establish? Does it mean there was no evidence? Does it mean there was insufficient evidence? Does it mean the standard was too high? Can you elaborate on that a little bit?
Certainly. Thank you, Dan. My colleagues, you've had a problem with my colleague's microphone. If for some reason you can't hear me and you want to, raise your hand. If you can't, you don't, keep your hands down. I'm going to try to speak into the other microphone. I mean, that is not unusual that evidence has not been established sufficient to warrant some type of criminal prosecution. It happens on a regular occasion. Prosecutors working with law enforcement investigators have certain thresholds that they have to meet in order to bring criminal charges. At least with regards to federal charges, I think as Joyce has already indicated, the objective is to have evidence sufficient to prove guilt beyond a reasonable doubt, and then beyond that to sustain a conviction should it be challenged upon appeal. So the burden is extremely high, and it should be high. It doesn't mean that people aren't charged and eventually acquitted for a whole host and range of reasons, including the insufficiency of the evidence. I think what's unusual here is the fact that there's been a pronouncement in terms of the result of a federal investigation. Most federal investigations are done privately, in confidence, protected in terms of the release of the information, in order to protect somebody who's under investigation but never been charged. Because the fact of the matter is, once you've made an announcement that somebody is under investigation, some people's immediate reaction is, then they must have done something wrong. And the ability to essentially get your reputation back becomes extremely, extremely challenging, and in some cases impossible. I know Dan talked about Bob Mueller's concern about fairness, and I have a great deal of respect for Bob Mueller. I had the opportunity to work with him. There's nothing in this report that would suggest anybody was concerned about the fairness to the President of the United States, his ability beyond kind of the public arena in terms of to defend kind of his actions, because everything became public, or most things became public through Bob Mueller's report. I looked at Bob Mueller's report in many ways to be very similar to prosecution memorandums that I'm sure Bob Mueller has written, probably hundreds of them, has likely reviewed thousands of them, as have my colleagues as well. Not every prosecution memorandum results in recommending charges. Some do, and charges have never been brought. But prosecution memorandums remain confidential documents within the Department of Justice, even after an indictment. But certainly if there's no indictment at all, it's rare that the results of a prosecution memorandum would be shared. And what do we know in terms of at least Bob Mueller's report? No conspiracy. No conspiracy by people associated with the Trump campaign to essentially conspire with the Russian Federation. And then he has this kind of big question about obstruction, as to whether or not there's sufficient evidence to bring obstruction. I would suggest this: if Bob Mueller knew and understood at the beginning of this process that he had no ability to bring obstruction charges against the president, why include in a report that he knew was going to become public some elements that may have resulted in obstruction charges under different circumstances? So I hark back to that comment about fairness. Where's the fairness here? Whether you like or dislike the president, whether you're offended by his conduct or otherwise, there still should be a basic fairness that should be afforded to him as well. And I think that this report doesn't properly give him the opportunity of fairness. There are many, I shouldn't say many, there are a number of public officials that we've all had the opportunity to investigate that never warranted federal charges and never became public. So their reputation was never harmed in the process. His is. I don't know how he rehabilitates that amongst certain members of the media and certain portions of the public.
So thank you. If I might follow up, are you suggesting that the investigation into obstruction in particular, excuse me, should not have taken place at all if a prosecution could not have been brought? Or are you suggesting that the report should have been much more summary or contain no factual allegations? How would you have structured it?
Well, again, I'm going to go back to the point that Bob Mueller made, that there's a Department of Justice policy that precludes the Department of Justice of bringing charges against a sitting president. And then he talks in his report about fairness, which includes fairness to the president, that no charges, no recommendation of charges can be brought, not because there's no underlying crime, at least Bob Mueller has not concluded that, but because there's no ability to bring charges. The Attorney General and the Deputy Attorney General, independent of that, made a separate determination outside of the limitations as it related to Department of Justice policy. So if in fact it was important to have that portion of the investigation done, there should have been a way to essentially keep that portion of the investigation much more highly confidential, to be used in a different place at a different time. If in fact that there is evidence and outside of a sitting president, charges could be brought, then you could pursue them under those circumstances. I just thought that Bob Mueller took steps that were unnecessary and not quite consistent with his role as a special counsel, including instructing Congress in terms of what Congress's rights are. I'm confident that members of Congress know full well, what their rights and their authorities are as it relates to a separate independent branch of government concerning potential impeachment.
Thank you very much. Let's move on to a second round, although actually I think maybe what I'd rather do, if I can change the protocol a little bit, is give other panelists a moment to just respond to each other, a quick lightning round, and then we'll have a second round of questions. I see everybody's nodding, so that's good. So Chuck, you want to go first?
Yeah, if I may. I like Mike, but I disagree with him on this. Let me explain why. The special counsel regulations, which replaced the independent counsel statute when it expired, require a special counsel to write a confidential report. Bob Mueller didn't release anything publicly. He wrote, as the regulations required, a confidential report to the Attorney General of the United States. The Attorney General of the United States, Bill Barr, then decided to release the report publicly. Now, Mike makes a really important point. That typically we do not make public our charging recommendations, and that out of fairness, if we're not going to charge somebody, it ought to remain private. I completely agree with him on that. But I want you to take away two things. One is Mueller followed the regulations that require a confidential report to the Attorney General. And two, as Joyce and I discussed earlier, it may be the case one day, and this is a whole separate debate, Dan, that the president can be charged when he's out of office. And so unusual to see a charging recommendation, absolutely. Mike's right. It wasn't Mueller who released it. It's also different. If the president is not above the law, he at least has a different law that applies to him. And these laws, I think, also counsel that we make an exception if we're talking about the conduct of the chief executive of the United States. Bill Barr determined it was appropriate to release this into the public domain. He did so. I think it's the right call. Parts of it were redacted, either because they were classified or because of an ongoing criminal and grand jury investigation. But I understand what Mike's saying, I understand why he's saying it. I think Mueller followed the rules here, and I think it was appropriate to dump into the public domain exactly what this president did.
Thank you, Joyce. You want to weigh in?
So I find myself in the position that I'm so often in on television when I follow Chuck, which is that I'm just going to wisely shake my head because he's made the 3 points that I would make.
This is the first time I've ever seen you not in a little box like the Brady Bunch.
I know, it's really weird, right?
Yeah.
But I would say that, little boxes aside, Michael does make, I think, a really important point. And the point is we shouldn't be quick to throw out the bathwater with the baby, right? Our hope is that we don't do anything that impairs the rule of law and its ability to continue to function in this country on an ongoing basis. So it's appropriate that we consider whether or not in a potential criminal investigative scenario, the president is treated fairly. It's really important that as we move forward, we not reach a result-oriented conclusion, as some people have, that they don't like the president, so, lock him up. That instead we are very careful about following the rule of law at every step in an investigation. But here I think the point is appropriate. Mueller wrote the confidential report that he was required to by the regs. and a decision was made by an attorney general who was appointed by this president to release these portions of the report.
Right?
I just point out perhaps the obvious, which I'm very good at these days, which is that the fact that there are people in this room and perhaps even on this panel who think that either Mueller and the report or its dissemination didn't go far enough, or that the Mueller report went too far, is a reflection of the incredible dilemma that the special counsel found himself in. And it's a reflection of Mueller, the man, as well, who tried to carefully walk the line and avoid appearances of partisanship and politics, but just to get it right and narrowly adhere to the rules he had to deal with. The other note I'd just throw out is, I do think that there is an overriding public demand and need in this unique time we're in for the public to become part of this conversation. It's not, we talk a lot about, well, if it were you or me, it's not you or me. It's the president of the United States. And so I think that the people need to understand what the issues were that were found and need to understand why, because our elected representatives now have to deal with this.
Thank you. So let's take that as an invitation to do a deeper dive into these issues in a second round of questions. And we'll have one more lightning round, and then we'll open it up to your questions. So get ready. Joyce, let's return to the question of the decision not to charge the president criminally. First of all, let's just get to it. Do you think that was the correct decision or not? And second, and I think this arises from the immediately preceding discussion, let's assume that an impeachment inquiry does begin in the House. Do you think that would just essentially be a do-over of the Mueller investigation? Would it relate to the investigation in some way? Would it use the findings? How would that look?
So first question, I think, is an easy one. Yes, Mueller made the correct decision not to charge. DOJ policy is that you don't charge a sitting president, and I think that that's game over. He could have certainly gone to the Deputy Attorney General, his boss, and asked for permission to violate that policy. I assume he did not do that because the special counsel regulations would have required disclosure if Mueller had made a request that he wasn't given permission to follow through on. But look, the reality is DOJ, like any other organization, operates on rules and chain of command. That's part of the rule of law structure. Mueller followed that, and although we may agree or disagree, we may think it would be different if the president wasn't a sitting president, he made the correct decision. The congressional decision is really an interesting one, and I had the privilege of testifying up on the Hill a couple of weeks ago and getting a little bit of a peek into what's going on up on Capitol Hill as they do what looks, I think, to everybody who's not Nancy Pelosi, like the beginning of impeachment proceedings. And it's a little bit of an unsettling process, right, to think about the fact that at least for the third time in my life, we're now sitting through this sort of a process that may result in the impeachment of a president. And it is a political process. It is not a criminal process. So what Bob Mueller did was he conducted an investigation into very specific criminal violations and concluded that he would not indict. That's not Congress's job. Congress won't be looking at those same statutes exclusively. They may look at them, but their impeachment jurisdiction would be to determine whether or not the president had considered high crimes and misdemeanors. And that is much broader, and it's a politically animated question, much more than it is a legal one. And then the last thing that I'll say is this. I think it's a mistake to prejudge this notion of impeachment. You know, as a prosecutor, you don't walk into your office one morning and say, I think I'll indict this defendant. Obviously, there's a lot of investigation that goes into that process before you get to the point where you make a prosecutive decision. And that same thing is true in impeachment. So I think it's healthy in a democracy to see Congress engaging in oversight and investigation. I think it's also a mistake to prejudge where that investigation might lead until all the results are in.
Thank you. Chuck, let's return to this OLC question a little bit and the charging decision. what do you think were the full range of Mr. Mueller's actual rationales for not recommending charges regarding allegations that the president obstructed justice? We alluded to this earlier, the constitutional questions, background norms, in addition to the OLC memo. And do you think that that was permissible, correct, wise? What do you think of the big picture?
Big picture, I think, well, first of all, I'm completely biased. I mean, I worked for Bob Mueller in the 2 years right after 9/11. Can I just tell a quick personal story?
Sure.
All right. I love the man.
Well, maybe you want to clear it with me first. Try it out.
Oh, you seem like the guy in charge, so I love the man, and I'm biased. I'd walk barefoot on broken glass for Bob Mueller. I often point out that working from occasionally felt that way. Well, when I interviewed with him, I don't know how many of you know Bob or knew him from his time here in Boston, but he does not waste time. He's an incredibly efficient guy. And so when I was ushered into his office, I had not met him before. He came around from behind his desk. I thought we would sit down and talk. We don't sit down because sitting is inefficient. So standing in the middle of his office, he didn't say hi, he didn't say welcome, he didn't say nice to see you. He said, why do you want to work here? And I answered the question. And he said, why do you think you'd be any good at this? And I answered that question too. By the way, this entire story took longer than my interview with Bob Mueller. And at that point, he says, okay, thanks for coming by. And he walks me out of the office. I'm thinking, this man hates me. This is the worst interview in my entire life. He absolutely detests me. And on the way out, trying to salvage this thing, I see a baseball on one of his shelves. I love baseball. I figured, oh, Bob Mueller's a baseball fan. We'll talk baseball. I'll turn this thing around. So I say, I see you're a baseball fan. And he says, nope. And out the door I go. He called me about an hour later. He said, he didn't say hello. He didn't say nice to meet you. He said, when can you start? And I said, 2 weeks, sir. And he said, see you in 2 weeks. And he hung up on me. I think he got it right, Dan. And the policy, again, we discussed earlier, never litigated, never adjudicated, is concerned with not burdening a president or stigmatizing a presidency with pending criminal charges. And if you think that's right, and I do, then you also have to recognize that recommending charges against the president have the exact same problem. They burden the president and they stigmatize the presidency. And so if you can't charge, then you can't recommend charging. And to Frank's point then, I think Mueller had to walk an incredibly fine line. He had to say what happened. That's his job, okay? But that's all he could do. And so he did make a recommendation in the first half of the report in which he said, we don't recommend the bringing of criminal charges for conspiracy with the Russians to interfere in the election or hack into protected computers or the like. If you're recommending not charging, that's fine. And volume 1 of the report does precisely that. But you can't recommend charging, which is why you see that quadruple negative you alluded to earlier in volume 2. If the policy is right, or if the policy binds you, and certainly the second thing is true, then you can't recommend or charge, you can't recommend charges against or charge a sitting president.
So while I've got you on this, let's move from the beginning discretionary point of the criminal justice system to the end point and the question of pardon, which has been a sort of leitmotif through a lot of the discussions. Doesn't figure in the report explicitly, but it's obviously a big part of it. Do you think there is a limit to the president's pardon power? Can the president pardon himself? Can he pardon anybody? Is there such a thing as a corrupt exercise of the pardon power?
Me?
Yes,
that's really hard. So there is a limit on the pardon power. It's contained in the Constitution. It says specifically that it will not apply in cases of impeachment. That's it. Other than that, it's silent. So again, how do we resolve stuff as lawyers and agents? In court. We ask judges to resolve these really hard questions for us, and they do, but this question has never been adjudicated. I think prudentially there has to be some limit on a president's power to pardon. For instance, if you had committed a crime, Dan, and had been convicted of it in federal court, he could pardon you, even if none of us liked it. Could he pardon you in return for a $5 million cash gift? right? Now, that just seems wrong. The Constitution doesn't preclude that. But again, prudentially, you would think, logically, you would think you couldn't buy a pardon for $5 million in cash. If you wanted to make Mike the United States ambassador to Ireland, fine, plenary authority, plenary power. But he probably couldn't do it in return for a $5 million cash gift. And so these Article II authorities of the president must have some prudential limit on them.
I might raise another question, which maybe we'll come back to, not only the corruption question, but the question of the separation of powers limit on the pardon. So, for example, if a president wants to pardon somebody for disobeying a legitimate order issued by a federal judge, that's a different kind of a potential limitation.
Right, but again, the Constitution doesn't preclude it. And so you would logically, you'd have to litigate it and ask the court to determine the limits on the pardon power. The only stated limitation on the pardon power is that it does not pertain in cases of impeachment, which suggests to some people you can't pardon yourself for anything because you can't pardon yourself for impeachment.
Thank you. Frank, let's return to some more specific details about the president's alleged conduct and its implications. Recently, the president said he would accept information about an opponent from a foreign power, and maybe he would not tell the FBI. Do you see a problem with that? Should I just toss that?
A rhetorical question. So look, if you'll bear with me, someone, as I was on the way in here, someone offered me a kilo of cocaine. And I think what I'm going to do with it is I'll sample it. And after having ingested it, I'm going to let you know whether I think anything bad happened and whether I'll be notifying the authorities about it. Essentially, that, as ridiculous as that example may sound, that's how the president's language sounds to me. I'm willing to accept a foreign power's information providing dirt on an opponent. There's, quote, nothing wrong with listening. And I don't know why you'd call the FBI. I've never called the FBI. Now, despite the fact that I've often heard mob bosses say, I would never call the FBI, there is something very wrong with the notion that a president seems not to understand the vulnerability he sets up for himself when he says something like that. And from my experience in counterintelligence, I know that the switchboards around the world in Foreign Intelligence Service headquarters were lighting up. Have you seen this? You know, I can almost hear Putin saying, can we get that translated right now? Because I need to know what the heck he just said. It sounded like he would take more dirt or that he'd be open to listening. And so I know that foreign services will do what they do for a living. They will attempt to help him. They'll attempt to test that. And again, it's not so much to get him reelected, but rather to completely sow discord and chaos back here. So I'm concerned that we know from reporting that as a candidate, he did receive counterintelligence briefings. He was told what a solicitation looks like. At the highest levels of the counterintelligence division of the FBI, he got briefed. His staff got briefed. And I've done those briefings before. I've given the business card and said, if you see anything that looks like what I just spent the last hour telling you about, give me a call. And by the way, what we are hearing is that they gave his staff specific examples of what was happening in real time, that he was being targeted. Crickets. From the president and his staff. So it's not so much that we've never had a foreign power try to interfere with our elections. It happens every election. It's that we've never had this level of receptivity from a candidate and his staff that I think is the most troubling.
Thank you. And what do you make of the distinction that Rudy Giuliani and some others have made between information that comes directly from a foreign intelligence service versus information that comes from foreign individuals or from more amorphous sources?
Well, I think it's a difference without any meaning. And by that, I mean, look, people don't walk around wearing signs that say Russian intelligence officer. That's not how it works. It's far more sophisticated than that. There are cutouts and co-optees and cooperators And Maria Butina can be an example of that. But we're going to see this on steroids as we approach the 2020 election, because now they know that we know how they operated. They've been indicted by name. So you're going to see even more of an attempt to mask and disguise the efforts to get to us. And so this distinction of, well, he didn't flash any credentials that said, KGB, SPR, FSB. Come on, we're all adults here. And so I support the legislation, very simple legislation that's been proposed, by the way, that says if a foreign representative, if a representative of a foreign government comes out and makes contact with you during a candidacy, we'd like you to report it. It's pretty simple. It really is. And I think the fact that the GOP has decided to look the other way on this proposal says volumes about where they're going. Thank you.
Michael, I'll give you the last word. I have a question, and if you want to respond to any of the other previous things, this would be a good time to do it. Mr. Mueller has repeatedly said that he does not want to speak to the Congress, that he has nothing to say outside of the report. He said, quote, "Any testimony from this office would not go beyond our report. We chose the words carefully. The work speaks for itself," end quote. So first question is, can he be compelled to speak? Do you think he could successfully fight a congressional subpoena in the court? And what more do you think he might say that would be useful or interesting?
Before I give an answer to the question, I want to give my Bob Mueller personal story as well. I don't have the same relationship that Chuck has with Bob Mueller, but the first time I met Bob Mueller was shortly after I became U.S. Attorney. I became U.S. Attorney for the District of Massachusetts several days after the 9/11 attack. And then shortly after that, the FBI invited a number of U.S. attorneys to FBI headquarters for a briefing by Bob Mueller. We had the briefing. We're all expected to leave FBI headquarters. And then somehow I ended up on the exact same elevator with Bob Mueller and his security entourage. I obviously was lost on the elevator, and I looked at Bob Mueller and I said, "Director Mueller, I look at your picture. I look at a picture of you every morning before I start working." And he looked at me very strangely, and I had to let him know I happened to be in Massachusetts, and his picture was on the wall that led up to my office. That was the last time they let me on the elevator with Bob Mueller. I'm sure most people would prefer not to have to testify before Congress under these circumstances. I'm also confident that if Bob Mueller was required to testify, was subpoenaed to testify, he likely would testify. Could he try to have the subpoena quashed or some type of protective order put in place? Sure. Would he be successful? I think highly unlikely for him to be successful under these circumstances. Would he try to narrow down kind of the breadth of the congressional inquiry so they could be well prepared, be responsive where he could, not answer questions that he couldn't that might be subject to some type of law enforcement sensitive information, particularly if it's in a public session with Congress? It's likely he would do all those things, but I think it would be very rare where somebody would be able to avoid a congressional, somebody in Bob Mueller's position would be able to avoid at least appearing some of the questions he may be precluded from answering, but likely would testify. Would he say much more than the report? And getting back to the report, probably not a lot more to be said. I understand there's some redacted versions that remain in the report itself. There are likely some things that didn't end up in the report, but it's a very comprehensive report. And Chuck Rosenberg is absolutely correct. The special counsel is obligated to prepare and file a report with the Attorney General after completing the task of the special counsel. But it doesn't say kind of the breadth or the depth of the report. I mean, the report could have been 30 pages long, and it could have satisfied the obligations of the special counsel. It obviously was much longer than that. So I think it's likely not a lot more would be said, but I don't know. I don't know what's not in the report that for some reason Bob Mueller would think would be important to disclose to Congress that it hasn't already been disclosed by way of the report.
Okay, thank you very much. We've obviously covered a lot of ground. Why don't we do one more quick lightning round if anybody has any last comments they want to make in response to anybody else or anything you wish I had asked you but didn't or you want to say, and then we'll open it up to questions from the audience. Anybody have any other things? No? Nothing? All satisfied. Good. Okay, well then let's give a round of applause, first of all, to the panelists. Really excellent presentation. My colleague, Zig Plotter, gave me a kilo of cocaine to give him the first question, so
I'll sample it for you.
please, go ahead.
Okay, it's an aftermath question. When Mr. Trump leaves office, whenever that is, I'm not thinking impeachment.
Oh, thank you.
He's done I teach environmental law, an extraordinary 70 different protections of environment, health, and safety have been trashed. But in many other areas, there has been a disruption of the civic protections that have been developed bipartisanly over the last 40 years. If, in retrospect, it appears that the election of 2016 was illegitimate because of Russian involvement, as Joyce was saying, the Mueller report was talking about a huge amount of Russian involvement. And I think, Frank, it's not just for 2020, the fear of voting machines or voting places, but Kathleen Holt Jameson talked about how the social media blitz, the avalanche, something more than 40 million messages, that's what changed how much of America was thinking about this election. If there's a delegitimation, in the aftermath, should there be a process to review, as Canada did after Stephen Harper, what protections need to be restored? Both regulatory, but then there's the further question, if the election turns out in retrospect to have been illegitimate, delegitimized, not only do you look at the civic protections that are lost, but more than 100 judges who are judges now because of that onslaught of information and disinformation from Russia. How's that for a quick
question?
So I think this question validates Frank's observation that Russia's real goal was never to get the president elected, that it was to destabilize our country so that down the road people would be asking just this kind of a question. That, I think, is the tragedy that we'll all face. One hopes that the rule of law will be strong enough to survive this, and that at the end of this administration, all administrations end, political decisions will be made by the incoming administration and by Congress about whether there are guardrails that need to be restored or whether there are structures, frankly, that have been weakened that need to be buttressed. But I don't think we can sugarcoat it. I think it'll be a more difficult transition after this presidency. We've not seen anything that says that Russia successfully altered the outcome of the election, but there will certainly be a conversation about the Electoral College and whether or not that process is one that we should continue to use. It will be, I think, a very difficult time to confront the questions that you raise.
Anybody else want to weigh in?
Well, there are those. So I don't see a will or a method in America to embark on that journey of determining whether or not we truly had a legitimately elected president. I think there's been no evidence, as Joyce said, of that. But the reason I focus so much on 2020 is because I fear that we may well be headed to a situation where we can't determine a legitimate winner. And there are theories that the lack of a forceful statement from President Trump on, I've put together a strike force to deal with 2020 election security. Here's the plan. Here's the budget. Here are the resources. Quite the opposite. If you talk to folks at DHS and other agencies, they'll say they probably aren't getting the resources or the backing from the president. And so the theory and some conspiracy theories amongst folks says maybe that's in part because not only does he want to appear to have delegitimized his own election by acknowledging there's a big problem, but secondly, because maybe it might help him for some hacking to have occurred, and then for him to declare that we can't determine a legitimate winner. And as Joyce said, put the win in the Russia column when that happens. If we end up with a situation days or weeks after election where we can't figure it out, Russia wins.
Reread Bush v. Gore if you want to see the leading precedent.
Well, and I think that's a good point. And in terms of the, it's not up to the president, the incumbent or the elected president, to make the final determination as to who the winner or loser is. Ultimately, it rests with the United States Supreme Court suggesting no constitutional crisis, even if there's a wide, varied opinion in terms of the results. Consequences have elections, and it's not unusual for elections that have lost for people to try to find reasons or excuses beyond the legitimate process. I think Joyce said it. There's been no evidence to suggest that the Russian interference essentially caused a result different than what the Electoral College process and the votes did. If that's the case, I'm not sure whether it's a year from now or 4 years from now, there's going to be any other consequences in terms of the 2016 elections. I mean, the fact of the matter is, he's been elected president of the United States through the process that we have in our country, notwithstanding the fact that there's substantial evidence, and I don't think there's much dispute about it, that Russian Federation interfered in the election, but there's no evidence to suggest it changed the results.
Okay, Scott Harshbarger has a question.
Yes, let me just, first of all, as chair of the advisory board of the Rappaport Center, we're very grateful to Frank particularly for his service before, but for getting all of you here. Secondly, because my wife is addicted to MSNBC, and I am here to convey my appreciation for that, as well as my admiration for the one person above all on the panel that she loves is Chuck Rosenberg. That was it. My serious question to you is this. I also chair Lawyers Defending American Democracy. We have been trying to figure out how to mobilize the legal profession as an independent profession, not as a partisan matter, not as advocates, but how do we get the legal profession, leaders of the academy, the organized bar, individual lawyers, as we did, at least I remember and feel, at Watergate, at the time of the Saturday Night Massacre, where the Bar Association stood up and delivered on behalf of the legal profession the rule of law and core democracy and legal values. The silence of the American Bar Association, of the organized bar, and leaders of our law firms and law schools, frankly, is deafening. And I wonder why, as I look at you, all of you, who speak so eloquently on behalf of the law in terms of fairness and the rule of law, how do we change that and find a way to have the center articulated by this allegedly independent legal profession?
Scott, first of all, make sure you keep the remote control close at hand. And go right to CNN if you ever see my face. Second, that's a hard question. We talked about it briefly before we started the panel. You know, there is virtue in the middle. I believe that. That many of these issues don't lend themselves to a left or right answer. They're predicated on, you know, the rule of law and enforcing norms. You know, we talked about some of them today. Mike brought up a really important one, the notion that we don't talk publicly normally about charging decisions, and particularly about people who decide not to charge. I've talked to a lot of people who say right now is a odd time, and the best thing to do is to stay out of the spotlight. You don't want to be in the Twitter feed, and I get that. But I think what we have to do are things like this. I think as members of the bar, right, or as people just concerned about the rule of law, we have to gather and we have to talk, and we have to do so civilly, and we have to listen to people on both sides of the issue, and we have to push it. Look, I by the way, Scott, tend to be an optimist. I really am. There's a marvelous book called The Soul of America by John Meacham, a Vanderbilt historian, which I would commend to you. And it mentions the fact that in our history, we have cycled through stuff like this before. This is not the first time. It won't be the last time. And so whether it's the treatment of Native Americans or the internment of Japanese Americans during World War II, or the Jim Crow South, or Father Coughlin, or Joseph McCarthy, or the rise of the KKK, twice, by the way, once after the Civil War and once in the 1910s and 1920s, we've faced difficult periods and difficult questions in our country. And we've come together somehow and we've talked our way through it. And so, you know, I tend to be an optimist. I tend to think we're going to be okay, Scott. But I do think we have to push the dialogue. And I don't know precisely how you do that. It looks different in different places. But what you're doing here, frankly, is exactly what we should be doing everywhere. And I do think the bar has to take the lead on it. I really do.
So I'm going to make a personal confession now and share with all of you that I'm a knitter. I've been a knitter since I was 4 years old. I knit all the time, and I enjoy it. And I'm also a member of an online network of knitters, sort of like Facebook for knitters, that has 8 million members. It's called Ravelry, and that's 8 million knitters worldwide, men and women. We do permit crocheters, even though we treat them with some scorn. And 2 days ago, Ravelry, this online hub, which is much like Facebook, a number of boards for conversation that are heavily frequented with people who visit them every day and actually make, you know, online friends who become in real life friends. Ravelry, Little Ravelry, a company that was formed by 2 programmers who quit their day job in 2007 to create this, sort of took that leap of faith and now have a big business that their family is wholly reliant on. They took the step of banning support for Donald Trump that amounted to support of white supremacy. And you might agree or disagree with that kind of a step. It has been debated heavily within the knitting community. But nonetheless, what your question says to me, what it really speaks to me of, is that I miss the absence of the ABA taking a stand on these issues, not in a political way, because that's never appropriate, but to stand up for some of the foundational values that we believe in and to help guide people. Because the American people do listen to members of the bar when we speak up. And I mentioned this letter that's been signed by prosecutors nationwide, 1,000 prosecutors, Republicans, Democrats, who looked at the evidence and weighed in on obstruction. Something similar happened in the early days of the Muslim ban, where a group of lawyers, Republicans and Democrats, weighed in on the constitutional validity of banning a group of people based on religion from entering this country. The bar has a moral voice and a constitutional voice, and it should not be afraid to use it.
I'm still pondering the knitting community. Actually, it's quite a yarn. Sorry. Yes.
I have to follow that. I think I know the answer Mr. Sullivan would offer to this question, so I'll direct it to the panel. And that is, are you satisfied with the Mueller report? If so, why? If not, why not?
Let me just repeat the question because they couldn't hear. The question was, were you satisfied with the Mueller report? If so, why? If not, why not?
Right?
I'm satisfied with portions of the Mueller report. I don't think it's serving us well in the society we live in. We live in a Twitter feed society. We get our news on social media or in a 5-minute clip after work, and maybe if we turn the television on. And in that environment, a standalone 400 some odd page report written in the way it is has not served us well. And I wish, I'm part of the room that wishes that Bob would have gone farther in the report to say clearly there is evidence of obstruction of justice that should be considered by the only party that can address it, which is Congress. And if I couldn't do it because of these protocols, then they should take a look at this. I wish it had been more clear in terms of a mandate.
Completely satisfied. I read it twice. It's a slog. I still nevertheless recommend it to you. I think he threaded the needle. What you see is an exhaustive, professional investigation. There are parts that are missing, but because they're redacted for 3 or 4 different reasons. But frankly, it's the redactions are incredibly light, much heavier in Volume 1 because it's the counterintelligence piece, and much lighter in Volume 2, the obstruction piece. And so everything you need to know is right there. I agree with the charging decision, or the decision not to charge or not to recommend charges in Volume 1. And I agree with the way they handled Volume 2, meaning you can't make a recommendation because of the policy that precludes charging a sitting president. Again, I told you early on, I'm biased. I have a bunch of friends who work for Bob Mueller as part of this investigation, and I think they got it right.
You know, with my prosecutor hat on, I'm completely in agreement with Chuck. I think that this was carefully threading the needle in an effort to preserve the system of the criminal justice process, which we all need to have preserved. With my private individual, with my curious mama of 4 kids hat on, I wish I knew more. But what that tells me is that Congress has a job to do here, and it is up to them to do it. It was not up to Bob Mueller to do it. He did his job.
And even though you didn't give me the opportunity to respond, my colleagues here on the panel said it was okay for me to comment as well. I would say this. It was like watching a 2-hour movie and liking an hour and 58 minutes of the movie, and then you got to the end. I hated the ending. And it's not because of what he put in the report, because from my perspective, I think Bob Mueller understood that a good portion of the report would be made public. I understand that the Attorney General ultimately released the report. I'm just troubled by the fact that you would spend 2 years, tens of thousands of hours, hundreds of investigators, dozens of prosecutors, hundreds of witnesses before a grand jury, thousands and thousands of reports reviewed, and you conclude by saying, but we're not exonerating somebody. To me, that's a very, very unusual statement that ends up in a report that ends up in the public. I don't recall in all the circumstances in which I investigated, whether we brought charges or didn't bring charges, that we talked about, but we're not exonerating you. It seems, getting back to this issue of fairness, how fair is that? If the report remained more confidential, I think it's instructive and helpful in terms of the Department of Justice to make certain assessments. I just didn't like the idea at the end of it that Bob Mueller would likely know the report would be made public. And then beyond that, I know Bob Mueller was critical of the summary that Attorney General Barr provided to Congress, suggesting that it was not entirely clear in terms of what the report indicated. My understanding is Attorney General Barr offered Bob Mueller the opportunity to review that summary in advance of releasing it, and Bob Mueller declined to do that. I'm troubled by that as well. And Chuck has a great relationship with Bob Mueller. I'll tell you, he's a real patriot. He fought in Vietnam. He served this nation in many different capacities. I have a great deal of respect for him. And it's not because it was Donald Trump in terms of the target. I felt that Jim Comey was wrong during the course of the election when he started making public the results of his investigation concerning Hillary Clinton. And I'll tell you here, if you're not know it already, I didn't vote for Hillary Clinton for presidency, but I thought he was wrong in terms of doing that because I thought it had the ability to influence the outcome of an election. He first Comey does the press conference saying, I'm not going to charge, and then lays out all the conduct that he believed was wrong by Hillary Clinton. And then later, very close to the election, he sends a letter to Congress essentially saying we found another cache of emails we're going to have to evaluate. Whether or not that had an impact, I don't know, but I thought it was wrong. My experience is those things are best done in a very private, confidential way. And if you make a decision to prosecute, then you make that announcement. There's a process in which we do it. So whether it was Hillary Clinton or Donald Trump, I thought in both instances it was wrong.
I think we have time for one more question.
Oh,
Oh, sorry, you were there. Okay. We'll have time for two more questions. I misspoke.
hi, my name is Kimberly Blair, and as a Rappaport Fellow, I would like to thank you for the opportunity to speak with you today. I hope I'm not stepping a little bit outside of the scope of why we were here today, but I wanted to know, in your opinion, how the results of this report will affect our decisions later, because you alluded to earlier the fact that we can't charge a sitting president, and how this decision could affect us after he comes out of the presidency, whenever that may be, to charge for other offenses that he has done during his presidency, specifically the situation we have with the concentration camps and the abuses against children. I wanted to know how this lack of prosecution now, resulting from the Mueller report, will set the stage for us moving forward after the president is done with his term.
Thank you. Before we respond, why don't we take both questions and then we'll give everybody a chance to respond to both questions and have a last word. We'll just package it.
Hi, I have no association with BC or with the legal profession at all, but I adore you guys. You have kept my sanity intact for the past 2 years. So did Barr prematurely shut Mueller down? How much of that was Mueller saying we're done, and how much of it was Barr being like, you're done?
Please respond to either or both questions.
So thank you so much for that kind comment. And I'll respond to the first question at least a little bit and say that the criminal justice system is a very blunt tool. And you know, if you only have one tool in your toolkit, if it's a hammer, every problem looks like a nail. That's the risk that we run here. Not every problem should be addressed through the lens of the criminal justice system. There are some that should be. There may be a point down the road where obstruction is addressed through the context of the criminal justice system. There may be other perceived crimes that are addressed in that way, but it is a very dangerous place to go. And at the end of the Bush administration, a very deliberate decision was made that there would not be prosecutions, quote unquote, political prosecutions of folks over the torture issue and other issues. That decision served the country well. That sort of deliberation and restraint is something that we should think about, and whether or not it's appropriate. Obviously, every potential crime has to be judged on its own facts, and not all conduct is the same. But it is very important, I think, as we move forward, that we recognize that we will be in a difficult time, as we have discussed, at least in part of Russia's making, and that we do what's best for the country as a whole, rather than sort of giving into whatever the mob mentality of the moment is.
Well, let me address the second question, which is, do we think that Barr maybe shut down Mueller, perhaps even prematurely, or was Mueller done? And it's clear that we have no evidence of a premature shutdown. And in fact, there are indications that Mueller was indeed wrapping, had planned to wrap. And I think we would have heard, I'll share a quick personal story. I think we would have heard from Mueller in some regard if he had felt that he was being prematurely shut down. There was without getting into classified information, there was a case that I had headed up at headquarters, and we presented it for prosecution. DOJ said no. We did not like the fact that DOJ declined to prosecute this case, and we even thought there might have been political reasons for them to do so. There was quite a bit of consternation within the Bureau. I let Mr. Mueller know that there were really agents who were quite upset. And one day he quietly called me up to his office and said, "Frank, I just want to let you know that I've put this in writing and told DOJ that we object to their decision." And this happened 2 or 3 times in my career. What's my point? My point is that he was a master at not pounding the table and screaming about what he objected to, but rather papering the file and saying, this was wrong, and we object. And I think we would have heard from him if indeed he was shut down prematurely.
Any last comments from anybody?
Yeah, I would agree. I think the lack of evidence suggesting that he was shut down prematurely means that there's no evidence to suggest that as well. I would agree with Frank. If Bob Mueller felt that there was more to be done concerning his role as special counsel, I think that would have been clearly communicated. What he announced was that he had completed his work as special counsel and was resigning from the Department of Justice.
I agree with Frank and Mike. I'm going to tack a postscript onto what Joyce said. It's actually an interesting story out of this Commonwealth. In 1974, Gerald Ford, I think, properly pardoned Richard Nixon. It was an act of great courage, although he was excoriated at the time, as you can imagine, by virtually every newspaper in the country, and by Senator Edward M. Kennedy, who I think, I don't know precisely what words he used, but they weren't kind to President Ford. In 2001, before the attacks of 9/11, Senator Kennedy gave Gerald Ford the Profiles in Courage Award at the John F. Kennedy Library here in Boston, and said he had reconsidered what Gerald Ford did. To Joyce's point that, the criminal justice system is a blunt instrument, Kennedy said that Ford really did demonstrate great courage in helping to navigate our country back onto a path in which we were looking forward and not backward at Nixon's disgraceful behavior. Ford, to the day he died, carried in his wallet an excerpt from a Supreme Court case called Burdick, which was decided, I believe, in 1915, give or take. And Burdick stood for the proposition that the acceptance of a pardon is really an implied acknowledgement of guilt. And that consoled Ford in his later years, because he too knew that what he had done was so remarkable and controversial. And so, I think there's a virtue in looking forward, not back. I think Joyce is right. We can't think of everything as a criminal justice problem in search of a criminal justice solution. And I just wanted to share with you that story of Gerald Ford and Senator Kennedy, because it may be instructive. We may find ourselves in a similar situation.
Well, on that optimistic note, thank you very, very much. Please check out the website of the Rappaport Center for future programming. I just want to offer my great thanks to our panelists for your service, for just an excellent panel. Thank you.